This is the Study for the Bar in Your Car podcast.
And we're your hosts, Claude and Ma.
Today, we're embarking on a really crucial deep dive. This is episode 2 of our Torts series.
Yeah, and we're zeroing in on two foundational intentional torts, assault and battery. You know, the ones that often get mixed up.
Exactly. We're here to help you really unpack these concepts, not just, memorize definitions.
We are essentially AI guides. We're brought to life by, AI magic, and more importantly, Angela's incredibly detailed torts notes.
Yeah, we like to think we sound pretty real, don't you? Some might even say we're a bit more real and maybe lucid than some law school professors on a Monday morning.
Just saying.
But speaking of Angela, for those of you who might be new here, Angela's the brilliant mind behind all these comprehensive notes.
That's right. She graduated from law school over in the UK first, and then dove into law school again here in the USA.
Which gives her notes this, unique perspective, right? That double dose of legal education.
Indeed. Like, for example, did you know that in the UK, torts is just called tort, no S?
Huh. Really? Like how they say sport instead of sports.
Exactly. Or maths instead of math.
Uh-huh. Maybe they just took the S from torts and, cleverly stuck it onto maths.
Right, maybe. Not to get too sidetracked, though, that little linguistic detour brings us back to why we're here.
Tort law. Or torts law, depending on where you are, I guess.
And today, like we said, we're really tackling intentional torts, specifically assault and battery.
These aren't just like abstract ideas, they're fundamental. They pop up everywhere in legal disputes.
Now, you might be wondering, where's Angela? Why isn't she doing her usual intro?
Well, she's a bit busy, as maybe you can relate to. She's deep in the trenches, studying for the bar exam herself.
So she asked us, Claude and Maud, to fill in, but don't worry, she'll definitely be back soon.
And in the meantime, if you need to reach out to Angela, maybe with questions about these deep dives, or just to send some, good bar exam vibes,
you can email her at podcast@studyforthebarinyourcar.com.
That's podcast@studyforthebarinyourcar.com. Easy enough.
Also, just a quick note, Angela works as a freelance law clerk.
Oh, yeah, that's right. So if you're an attorney, or maybe you know one who needs some ad hoc help.
With legal research, LexisNexis, writing motions, complaints, writs, answers, briefs, that sort of thing.
You can reach her for that kind of work at hello@legalwriterandlawclerk.com.
Okay, great. So, with those important intros out of the way, let's dive into Angela's notes for today. This is where we start building that strong foundation.
Okay, let's unpack this. Intentional torts. These are like a fundamental part of tort law, right?
Absolutely. They're not about carelessness or, negligence. They're about a deliberate act, an intentional act that causes harm.
And Angela's notes kick things off by outlining the core requirements, the things that apply to pretty much all of them.
Exactly. It sets the stage. And what's really crucial here is understanding the prima facie case.
Right, the basic case you need to make. Sufficient on its face unless disproved later.
Precisely. And for any intentional tort, the plaintiff generally has to prove 3 foundational things. These aren't minor points, they're the bedrock.
Without these 3, the case just falls apart.
Pretty much.
Yeah.
So, pillar number 1, an act by the defendant.
Okay, an act sounds simple, but I bet there's nuance.
There is. It isn't just a thought, it has to be a volitional movement, something the defendant consciously chose to do.
Volitional, so like consciously willed. Not an accident or reflex.
Exactly. Even a small movement counts if it's volitional. Angela's notes point out, falling asleep at the wheel isn't volitional for tort purposes.
But deliberately taking your hands off the wheel would be.
Right. So that's the act. Then, building on that, the second pillar is intent by the defendant.
Intent. This is where it gets tricky, isn't it? Especially coming from, criminal law, maybe?
It really is nuanced in torts. It's not necessarily about malice or ill will, or even knowing what you're doing is technically wrong or illegal.
So what is the intent required then?
According to Angela's law school notes, it's basically the desire to cause the consequences of the act. Or knowing with substantial certainty that those consequences will happen because of your action.
Substantial certainty. Okay, so you don't have to want the harm. Just know it's almost definitely going to result from your act.
That's the key distinction. It's about directing your will towards an outcome, or knowing that outcome is basically guaranteed, not about your motive.
That substantial certainty part seems really important. It broadens things beyond just explicit bad intentions.
It does. It holds people accountable even if they claim they didn't realize the danger, provided a reasonable person would have known the outcome was substantially certain. Angela's notes have a great example.
Oh, yeah. Lay it on us.
Okay. D stores gas-soaked rags in his garage in the summer, which is dangerous. A fire starts and burns the garage of P, his next-door neighbor. P sues D for damages.
Right. So D stores the rags. Fire happens. P's garage burns.
D truthfully claims that he didn't know storing rags like that was dangerous. It doesn't matter. D is still liable.
Wow. Okay. So even though D didn't want the fire and maybe didn't know it was dangerous, he's still liable. Why?
Because the act of storing them was volitional. And a reasonable person would know storing gas-soaked rags in summer heat carries a, well, substantial certainty of fire.
So the intent was to store the rags, and the fire was a substantially certain consequence of that intentional act under those conditions. It's objective.
Precisely the logic. The focus is on intending the act and the objective foreseeability of the result, not D's subjective belief about the danger.
It makes sense from a policy perspective, holding people responsible for foreseeable results of their actions.
Exactly. So we have the act, we have the intent. What's the third pillar?
The third is causation of the result to the plaintiff from the defendant's act.
Right. Did that intentional act actually cause the plaintiff's harm? There needs to be a direct link.
It can't just be like a coincidence. It has to flow from the defendant's action.
And this raises the question, how do we actually prove this causation in intentional torts? Angela's notes lay out two main tests for actual causation, or cause, in fact.
Okay, two tests. What's the first one?
The first is usually the most intuitive one, the but-for test.
The but-for test, okay. Sounds simple. Is it?
In many cases, yeah. The plaintiff has to prove that, but for the defendant's specific act, the plaintiff wouldn't have been injured.
So you kind of mentally remove the defendant's action.
Right. And if the injury still would have happened anyway, then the but-for test isn't met. The defendant's act has to be a necessary condition.
Angela's notes confirm that. The but-for test is satisfied if the victim's injury would not have occurred without the actor's breach of duty.
Makes sense. It isolates that one action as essential.
And there's an example in the notes, too, about a drunk driver and a paramedic.
Oh, yeah, that's a good one. Lay it out.
Okay. A driver who has been drinking is involved in an accident in which the plaintiff is knocked unconscious. A paramedic arrives and negligently treats the plaintiff, causing head injuries.
Two separate harms there.
Exactly. And the notes say the but-for test works for each distinct injury. The plaintiff wouldn't have been unconscious but for the drunk driver's action.
And wouldn't have the head injuries but for the paramedic's negligent treatment. Clear, singular causation for each harm.
Right, but what if things are more complicated, like multiple causes? Does but-for still work?
Ah, good question. That's where the second test comes in. What happens when the but-for test is hard to apply because maybe multiple things could have caused the harm?
That's where we use the substantial factor test, right?
Precisely. Angela's notes say we use this when there are multiple potential causes, or maybe multiple defendants acting.
So the defendant's act doesn't have to be the only cause, or even a necessary cause in a but-for sense.
Exactly. It just needs to be a substantial factor in contributing to the injury. It's about material contribution, not singular necessity.
Okay. That seems more flexible for messy, real-world situations. Is there an example for that, too?
Yep, a classic one involving horses and scooters.
Horses and scooters. Okay, I'm listening.
Imagine a horse-drawn carriage in the park. Two motor scooters drive up on either side, backfiring and making noise.
Uh-oh. I see where this is going.
The horse gets frightened by the noise and bolts, throwing the driver off, who is injured. Now, the tricky part.
The noise from either scooter could have scared the horse on its own.
Potentially, yes. So it's tough to say that, but for scooter A's noise, the horse wouldn't have bolted, because scooter B was also making noise, and vice versa.
So the substantial factor test looks at whether each scooter's noise was a substantial factor in causing the fright.
Exactly. Both actions contributed materially, even if neither was individually necessary in a strict but-for sense.
That makes a lot more sense for situations with multiple actors or causes.
It does. And Angela's notes even mention a case, Lasley v. Combined Transport, that highlights this.
Oh, yeah. What happened there?
Well, Combined Transport spilled glass on the road. The plaintiff was in a collision nearby. The court found the spilled glass was not a but-for cause of the injury. The collision might have happened anyway. But the next question was the spilled glass a substantial factor in the severity or nature of the injury? It shows how a factor can contribute significantly, even if it isn't the sole but-for cause.
Okay, so act, intent, causation. Those are the general building blocks. Now let's get specific. First up, Battery.
Right, battery. What exactly is it, legally speaking? It's more than just, physical fighting.
Well, Angela's notes define it pretty clearly.
Mm.
It happens when a defendant intentionally causes harmful or offensive physical contact with the victim's person.
Harmful or offensive contact, intentionally caused.
Right.
Okay, and the purpose is to protect what?
Bodily integrity. That fundamental right to control what happens to your own body, free from unwanted touching.
The right to sort of inviolability of your person.
Got it. So let's break down those elements for battery. First, intent. We covered intent generally, but how does it apply here? Do you have to intend the specific harm, like a broken nose?
Good question. No, not necessarily the specific harm. The intent required for battery is the intent to cause the contact itself, the touching, which turns out to be harmful or offensive.
Or knowing with substantial certainty that the contact will result from your actions.
Exactly. You intend the push, the touch, the grab. If that intended contact is harmful or offensive, that's battery, even if you didn't specifically intend the injury that resulted.
Okay, so intent to make contact. What about the contact itself? Harmful or offensive contact? How's that defined?
Harmful is the easy one. Physical injury, pain, illness, a cut, a bruise, making someone sick. That's harmful contact.
Right, but offensive, that seems more subjective.
It is, but the standard is objective. Angela's law school notes say it's contact that would offend a reasonable person's sense of personal dignity.
A reasonable person. So it's not about whether the victim was particularly sensitive.
Correct. It's about what society generally finds unacceptable. Spitting on someone might not cause physical harm, but it's definitely offensive to a reasonable person's dignity.
Okay, that makes sense. And the contact must be with the plaintiff's person. Does that literally mean just their body?
Not necessarily just skin to skin. Angela's notes clarify it includes anything intimately connected with the plaintiff's body.
Intimately connected. Like what? Their clothes, something they're holding?
Exactly. Things like clothes, a hat, a bag they're carrying, even something they're sitting on. It extends the protection a bit.
The notes have that example about the restaurant tray.
Yes. A restaurant employee struck a tray from a patron's hands. Because the tray was intimately connected to the patron, knocking it away was considered contact to the plaintiff's person for battery.
So it can be indirect contact.
Definitely. Or even remote contact. If someone throws something like a rock or a ball and it hits the victim.
That's battery too, even though the defendant didn't physically touch them directly.
Right. The defendant intentionally caused the object to make the harmful or offensive contact.
And, of course, causation. The defendant's intentional act has to actually cause that contact.
Yep. The but-for and substantial factor tests we discussed earlier would apply here to link the defendant's intentional act to the harmful or offensive contact. No causal link, no battery.
Okay, so if battery is proven, what about damages? What can the plaintiff recover?
Typically two main types. Actual damages and punitive damages.
Actual damages are for compensation, right?
Yeah.
Making the plaintiff whole.
Exactly. Covering things like medical bills, lost wages if they couldn't work, and compensation for pain and suffering, emotional distress stemming from the physical contact.
And punitive damages. Those are the punishment ones.
Right, for punishing the defendant and deterring others. But as Angela's notes stress, you don't get punitive damages just for negligence.
It requires more culpability, especially for intentional torts like battery.
Yes. The standard mentioned is acting with reckless indifference to others' rights.
Reckless indifference. What does that actually mean? It sounds serious.
It is. It's more than just intending the contact. It's acting with a conscious disregard of a substantial, unjustifiable risk that harm will occur. Like really outrageous conduct.
A gross deviation from how a reasonable person would act.
Precisely. And while punitive damages can be much larger than compensatory ones, there needs to be a reasonable relationship, a ratio between them.
The Supreme Court has weighed in on this, right? Like 10 times larger might be okay, but 500 times larger is probably excessive.
Exactly. It depends on how egregious the conduct was, and sometimes how hard it is to quantify the actual harm.
Okay, one more key thing about battery from the notes. Awareness of contact. Does the plaintiff have to know they're being touched at the time?
This is super interesting and important. No, they don't. The plaintiff does not need to be aware of the contact when it happens.
So you could be asleep or unconscious.
And still be the victim of a battery. If a surgeon performs an unauthorized procedure while you're under anesthesia, that's battery, even though you weren't aware at the time.
Wow. It really protects bodily integrity, regardless of your perception at the moment.
That's the core idea. Okay, so that's battery. Shall we move on to its often confused cousin, assault?
Let's do it. Assault. People use this term all the time, often interchangeably with battery. But legally, it's different. What's the legal definition?
Right. Legally, assault protects a different interest. It's not about the physical contact itself. Angela's notes say it's about protecting your mental tranquility, your right to be free from the apprehension of an imminent battery.
Apprehension. So it's the threat, the feeling that you're about to be hit or touched offensively.
Exactly. It's the invasion of your peace of mind caused by reasonably expecting an imminent harmful or offensive contact. The swing and miss could be assault, even if no contact occurs.
Okay, elements of assault. Starts with intent again.
Always. For assault, the defendant must intend to cause the victim to apprehend that imminent harmful or offensive contact.
Or the intent to actually cause the contact itself, and the apprehension just happens as a result.
Yes, either way works. They either want you to think you're about to be touched offensively, or they intend the offensive touching, and their actions make you think it's coming. The goal is creating that apprehension.
Okay, next element, reasonable apprehension. This sounds key. Does apprehension mean the victim has to be scared?
This is where it gets really interesting, and it's a common mistake. Angela's notes are very clear. Apprehension here means expectation, not necessarily fear.
Expectation, not fear. So even if the victim isn't afraid, they can still apprehend a battery.
Yes, as long as a reasonable person in the victim's position would have expected the contact. Think about a very large person being threatened by a very small person. The large person might not be scared, but they could still reasonably expect or anticipate that a contact is imminent based on the threat.
So the focus is on the victim's reasonable belief that a battery is about to happen, not their emotional reaction to it.
Precisely. And the notes have that classic unloaded gun example.
Right. Tell us that one again.
An assailant pointed an unloaded gun at a woman and verbally threatened to shoot her. The woman did not know that the gun was unloaded.
Okay, so she thinks it's real.
Right. Now, objectively, the assailant couldn't shoot her. But from the perspective of a reasonable person in her position who doesn't know it's unloaded, the assailant had the apparent ability to shoot.
Apparent ability. So even if they can't actually carry out the battery, if it reasonably looks like they can, that's enough for apprehension.
That's generally the rule. The apparent ability is key.
And the apprehension must be of an imminent battery. What does imminent mean here, like right now?
Exactly. Imminent means it's about to happen without significant delay. Threats of future harm don't count as assault.
So saying, "I'll get you next week," isn't assault, even if it's scary.
Correct. It has to feel immediate. A threat from across a wide field might not be imminent, but someone shaking their fist right in your face probably is.
What about words alone? Can just threatening words constitute assault? Like yelling, "I'm going to punch you"?
Generally, no. Angela's notes suggest words alone are usually insufficient. There typically needs to be some accompanying overt act or gesture that puts the threat into immediate context.
Like raising a fist or pointing the gun in that earlier example. The words combined with an action.
Exactly. The action makes the threat feel immediate and plausible, creating the reasonable apprehension of imminent contact. Just words floating in the air usually don't cut it.
Makes sense. And damage is for assault, since there's no physical contact in a pure assault.
Right, you wouldn't have medical bills for the assault itself, but you can recover actual damages for the emotional distress.
Like anxiety, fear, sleeplessness caused by that apprehension.
Yes. The mental anguish is compensable. And just like battery, punitive damages might be available if the defendant's conduct was particularly egregious, showing that reckless indifference.
Okay, so we've got battery, contact, and assault, apprehension. Let's nail down the key distinctions in relationships.
Absolutely. They often happen together, but they are distinct torts protecting different interests.
The number one distinction seems to be
Contact versus apprehension. Battery requires harmful or offensive contact. Assault requires reasonable apprehension of imminent contact. Physical invasion versus mental invasion.
Got it. And the second big one?
Awareness. Remember, for battery, the victim doesn't need to be aware at the time of contact.
But for assault, the victim must be aware. They have to perceive the threat to apprehend it.
Precisely. No awareness, no apprehension, no assault.
Can you have one without the other? We touched on this, but let's clarify.
Definitely. Angela's notes give clear examples. You can have battery without assault.
Like getting hit from behind. You had the contact, battery, but no warning, so no apprehension beforehand, no assault.
Perfect example. Or contact while unconscious, Conversely, you can have assault without battery.
That's the swing and a miss.
Or,
Or the unloaded gun scenario. You apprehended the contact assault, but it never actually happened. No battery.
exactly right. And one more crucial point here. The no merger doctrine.
Right. This means if both happen, they don't merge into one claim.
Correct. If someone threatens to punch you, assault, and then actually punches you, battery, the plaintiff can sue for and recover damages for both torts separately. They protect different interests, so you can recover for violating both.
Okay, that's a really important practical point. Now let's talk about shared concepts and defenses that apply to both.
Good idea. Some underlying principles and ways defendants can avoid liability even if the elements are met.
We keep coming back to intent, but it's worth maybe one last mention.
Just to reiterate, for these intentional torts, it's the intent to do the act that results in the contact or apprehension, not necessarily intent to harm or break the law. That objective standard is key.
Okay, now what about transferred intent? This sounds like a really interesting legal concept.
It is. It's a way the law handles situations where the defendant's aim is off, so to speak.
Like you intend to hit person A, but you accidentally hit person B.
Exactly. Or maybe you intend one tort, like assault, but end up committing battery instead. Angela's notes explain this well.
So the doctrine says the intent can transfer. How does that work?
An actor intends an intentional tort against one person, but ends up committing 1, a different tort against the same person, 2, the same tort against a different person, or 3, a different tort against a different person.
And in those cases, the original intent transfers over to what actually happened.
Yes. It applies to assault, battery, false imprisonment, trespass to land, and trespass to chattels.
So back to the example. I swing at A, intending battery on A ducks, and I hit B.
Under transferred intent, your intent to batter A transfers to B. You're liable for battery against B, even though B wasn't your target.
The law doesn't let you off the hook just because you have bad aim.
Pretty much. You intended a wrongful act, and a wrongful act resulted.
What about the mistake doctrine? How does that relate to intent?
Generally, a defendant's reasonable mistake about a surrounding fact doesn't negate the intent for an intentional tort.
So if I reasonably but mistakenly think I'm on my own land, but it's actually my neighbor's, my intent to enter that specific land is still there.
Exactly. The act of entering was intentional, even if based on a mistake of fact about ownership. That could still be trespass.
Same for battery.
Yeah.
If I intend to touch someone, mistakenly thinking they consented.
Generally, the mistake about consent might not negate your intent to touch. However, there's a big caveat with informed consent.
Ah, right. If the victim's consent was based on a mistake that the actor knew about.
Yes, and the mistake related to the nature, risks, or harm of the interaction, then the consent might be invalid. But if the actor didn't know about the victim's mistake, the mistake usually doesn't invalidate the consent.
Okay, that's nuanced.
Yeah?
Now, defenses. Even if the plaintiff proves act, intent, causation, the defendant might have a justification.
Right. These are affirmative defenses. The big ones for assault and battery are consent, self-defense, and defense of others.
Let's start with consent. If the plaintiff agreed to the contact,
Then it's a complete defense. No liability. Consent can be express, written or spoken, or implied.
implied like in sports, you consent to the normal tackles in football.
Exactly. But only the contact that's ordinarily part of the game, not like intentionally breaking rules to injure someone outside the scope of play.
And we already touched on informed consent. It has to be knowing consent, especially if the actor knows the victim is mistaken about key facts.
Correct. Invalid consent isn't really consent at all.
Okay, next defense, self-defense. Using force to protect yourself.
Yes, it's a privilege to use reasonable force to protect yourself from an actual or apparent imminent battery.
Reasonable force, that means it has to be proportional, right? You can't use excessive force.
Absolutely critical.
Oh.
Angela's notes say you can use no greater force than you reasonably believe necessary to stop the threat.
So if someone pushes you, maybe you can push back, but you can't escalate wildly.
Right. You might be privileged to threaten greater force to deter someone, like pointing a gun, but actually using that greater force might not be justified unless the threat escalates. Proportionality is key.
And what about deadly force in self-defense?
That's only allowed if you reasonably believe you're in danger of death or serious bodily harm.
A very high standard. And the threat has to be imminent.
Yes. Reasonable belief of imminent death or serious bodily harm. And crucially, you generally can't use deadly force just to protect property.
Right. Saving your TV isn't worth taking a life.
The law values life over property in that calculation.
What about defending someone else? Is that allowed?
Yes, that's the defense of others. You can use the same degree of force to protect a third person that the third person would be privileged to use themselves.
So you basically step into their shoes, applying the same rules of reasonableness and proportionality.
Exactly.
One last important point on defenses from Angela's notes. Negligence defenses like contributory negligence or assumption of risk.
Do not apply to intentional torts like assault and battery.
That's huge. Why not?
Because these torts involve intentional, purposeful wrongdoing by the defendant. The focus is on their intent, not the plaintiff's carelessness. You can't contribute negligently to someone else's intentional attack in the same way you might in an accident.
Got it. That's a critical distinction for exam takers. Okay, so wrapping up the substance. Any final thought for the learner?
Well, we've seen how precise these definitions are. Assault, battery, they seem simple, but the legal elements are specific.
And distinguishing them is vital.
Right. So here's something to think about as you analyze fact patterns. How does the victim's subjective experience interact with the objective legal standard?
Particularly with assault's reasonable apprehension element.
Exactly. What if someone has an unusual phobia and they experience extreme fear from something a reasonable person wouldn't find threatening? Does that subjective terror change the legal analysis for assault?
The standard is objective, reasonable apprehension, not subjective fear.
Right. So how do courts navigate that tension? It really underscores why you need to focus on applying the objective legal standards like reasonable apprehension to the specific facts, even when the victim's personal reaction might seem compelling. It's about the rule of law, not just individual feelings in that specific element.
A great point. Focus on the legal standard. Okay, yeah. I think that covers the core material.
Yeah, that wraps up our deep dive into assault and battery.
We really hope this breakdown of Angela's notes gave you some clarity, maybe a few aha moments. Mastering these basics is so important.
Absolutely. And as we saw again and again, evidence is everything in tort law.
Right. Proving intent, causation, the nature of the contact or apprehension, it all comes down to evidence. Without it, you don't have a case.
It's the foundation for everything.
And before we sign off, a huge thank you, as always, to Angela for sharing her fantastic torts notes. Seriously invaluable stuff.
Definitely. Okay, just a few quick housekeeping items before we go.
Shoot.
First, please remember Angela is a student, just like many of you listening. She's not an expert yet, hasn't passed the bar yet. She made this series to help herself study, and we're just sharing that journey.
Good point. Second, neither Angela nor this deep dive is giving legal advice. Please don't construe it that way.
Yeah, think of us as study buddies, not your lawyers. AI, even convincing AI like us, isn't a substitute for actually studying the law or getting real legal counsel.
Third, while Angela does her best with the notes, and we try our best to convey them, AI isn't perfect. Sometimes we might make mistakes.
Angela does try to fix any errors if they pop up, but always double check against primary sources.
And finally, especially if you're studying for the bar in your car, please be safe.
Your safety on the road is number one. If learning about torts gets distracting, hit pause, listen later.
We definitely don't want you causing a tort while listening to torts.
Indeed. And just a reminder, Angela's contact info for podcast questions or freelance clerk work is in the show notes.
All right, then. As tradition dictates, time for a cheesy lawyer joke.
Oh boy, okay, let's hear it.
Why did the tort lawyer break up with the civil procedure lawyer?
I don't know why.
Because he said there was no duty of care in their relationship.
Ooh, okay. That was appropriately cheesy.
Okay.
All right, this is Claude and Ma, your AI bots, signing off. See you on the next deep dive.
Goodbye and thank you.